These are appeals in the matter of DSM IP assets in another, and Algal omega-3 and Mara Renewables.
My Lords, I'm here with Dr. White from Mara. My learned friend Mr. Abrahams and Ms. Nizami are here for DSM. As my Lords know, there are two appeals, one from each of us.
Yes.
They're related in that the prior art in the first appeal, mine, is also raised as a respondent's notice point, and in fact the patent, or substantially the patent in the first one, is the prior art in the second. And so what my learned friend and I have done is to agree that we're going to split the time available between us equally and structure the submission subject, of course, to my Lords, by me opening the 151 appeal.
Yes.
My learned friend then standing up and answering that and opening his appeal, me responding, and then a very short reply on his appeal. So 4 speeches rather than splitting it into 6, because there is an overlap in subject matter. So that's what we propose to do. So we're dealing with both appeals
Okay.
because they overlap.
Yes, they do. Yes.
So that's the proposal, my Lord.
And when you say split the time, what time are you splitting?
The time available in the 2 days. So
you are splitting the 2 days.
Yes.
Okay.
So that I'm going to hopefully sit down, ideally before lunch, because I'm only dealing with 1. My learned friend will then be significantly longer in his speech because he's dealing with 2.
Yes.
And then I'll get up again tomorrow sometime.
Okay. Okay.
My Lords, there's one other matter of housekeeping before we start, and that's it's agreed, again subject to my Lords, that there should be a 3122 order to preserve confidentiality in the materials that have had to be put in the bundles, but nobody's going to refer to. It's just they're on pages where other materials.
So they would otherwise be disclosable.
Yes, and we've agreed. I've got a schedule. I can hand it up if you want, but it identifies the pages. And the order that we've agreed is not that the whole page, but the bits that are highlighted in my Lord's bundle as confidential remain confidential, notwithstanding they're in the bundle.
And do you have a draft order?
Not a draft order, but I've got the schedule identifying every page. I'm not sure it'll help.
Okay.
Perhaps you can agree a draft order.
We will. We've agreed that there should be one, and we've agreed it only relates to the highlighted.
Yes. And as you say, you're not going to refer to them.
No.
But it's because they're in the documents and otherwise...
Exactly.
Okay.
And my Lords will have seen that the bundles have got confidential written on them because of that, but the skeletons don't.
Yes.
And that's because we don't think...
Yes. But as my Lord says, can you agree?
We will certainly do
send it through. Please.
Now, my Lords will have understood the technology we're concerned with in both appeals is the production of single-cell oils, and we're typically concerned with oils that contained polyunsaturated fatty acids, or PUFAs, as the acronym goes. And a particularly well-known subclass is omega-3, where the unsaturated carbon-carbon double bond is 3 in from the end, and the name comes from the fact that omega is the last letter of the Greek alphabet. You go to the end and you count back 3. And within that class, a fatty acid known by the acronym DHA, which is short for docosahexaenoic acid, I think, if I've said it correctly, it was well known to be advantageous for the human health and development point of view. My Lords will no doubt know that about the use of fish oils in our diet as a good source of omega-3 fatty acids. And when you eat that, fish or perhaps oil extracted, you're only going to the middleman, so to speak. The fish don't make the omega-3 fatty acid, but they consume it in their diet, either directly from the marine algae, or if they're bigger fish, they've eaten something else in the food chain which eventually will have eaten the marine algae. And so this industry is all about cutting out that middleman and going direct to the microbes that make the lipids containing the omega-3 fatty acids, such as DHA. And you're interested in growing up large quantities of single-cell microbes, so you ferment them in a large tank under conditions to increase their number, then you change the conditions to increase their lipid content, and then you take the lipid out of that mixture. That's what this industry is about. And the basic idea is once you've got a large tank and it's ready, you pop or burst the cells, and the technical term for that is lysing them. And then you separate the oil from the rest of the mixture, so for the surrounding liquid and the cell debris. And that's the basic thing that this industry is all about, this technology is directed to. Now, my appeal is on EP 155, which is the earlier of the two patents. The priority date for that is May 2002. And if I may, I want to just pick out some of the key aspects of the common general knowledge of the skilled team in the field of single-cell oil production at that date. And the first point I'd like to pick up is actually a point on the skilled team itself. Their interest is obviously the production of microbial oils, but it's not limited to the commercial scale. Smaller scale laboratory use in industry and academia is within their remit too. And the judge dealt with this in the judgment on the skilled team. Can I just show you where he picked up this point? So, my lords need the judgment in core bundle tab 12, and the bundle page is 156. Firstly, at paragraph 38, left-hand side, about where the top hole punch is. And this is where he says it's not only processing at a commercial scale, or in effect the people who keep a commercial process running. He says they would have experience of experimenting in the lab and scaling up. In other words, as he says here in the last sentence, they have the non-inventive ability to develop processes, not just to run them. And while we have this page open, we can see the impact of this point at paragraph 43 to 46. So at the bottom of the page and then over to the top of the next. It's the qualification as to the approach of Mr. Dweppen and Dr. Wynne, my friend's experts. They had focused very much on commercial scale production. He says it wasn't their fault, but those instructing them, because it suited DSM's case. And paragraph 45 is particularly worth drawing attention to because the judge explains that the cross-examination provided that enzymatic lysis and other non-mechanical lysis methods were CGK because they would be used and explored at small scale in laboratory, either in industry or academia. And that's important for my lords to note because I think my friend's submission is that enzymatic lysis was not known on any scale, which is just wrong in my submission and contrary to that finding. So they were interested not only in the large-scale processes to keep them running, but in developing processes, which is obviously done initially at small scale in a lab. Now that brings me to the key aspects of this common general knowledge, and the judge addressed this topic in a lengthy section. The whole section is from this page, paragraph 47, right through to 174. Can I just pick out a few points for my lords? Pick it up, please, at 114 on page 171. And I'm taking you here because the judge gives an overview of microbial oil production. And you can see from the introductory words above the picture that he's doing so by reference to the process used by a dominant player in the industry at the time, Martech, to produce the Dasco oil. And that uses a well-known strain called C. coni. Now we can skip over the details concerning growth and separation of the biomass and pick it up at 122. This is still in the section dealing with this Martech process. So I'm on page 174, and this shows how the oil is extracted from the biomass, which you see is shown at the top left hand as a sac, and that's because in this process it's been stored dried. And what happens here is that the cells and hexane are mixed to form a slurry, which is then passed to the mechanical cell disruptor. You see that is the one on the right-hand side labelled F, and that's described in paragraph 123 under the diagram. And what's explained there, and on to 124, is this specific mechanical method of lysing. And you see in 124, 1 and 2, you can do it mechanical lysis by homogenization or a technique called bead milling. And that goes over to the top of page 175. And that's another way to exert high mechanical forces on the cells to burst them open. To put it simply, you whack them as hard as you can and you burst them. And I don't think anything turns on using one or other of these techniques, and I might occasionally use homogenization to actually mean mechanical, the broader category, which includes bead milling as well. Now, for completeness, you see the judge at para 125 refers to other lysis techniques and says he will resolve the dispute as to those later. In fact, as we've already seen, he's also foreshadowed his conclusion on enzymatic methods earlier when he was addressing the skilled team. Now, if we pause at this point in the process, so at the lysis point in the DASCO exemplar process, what you've now got is a mixture of hexane and the burst lysed cells. And hexane is a non-polar solvent, so the lipid that was inside the cells, when they burst open, dissolves in the hexane. And that's sometimes referred to as solubilizing the lipid. But the residual water from inside the cells, which now contains the cell debris, is obviously polar, and they're separable. And that's what's shown in the diagram on page 174 in step G. And it's described in paragraph 126 as actually achieved by centrifuge or possibly decanting. You generally use a centrifuge in all of these methods, even one with hexane. So we've now got our lipid dissolved in hexane, separated from the water and the cell debris, and the hexane can be evaporated off, and you can condense it and recycle it to use it again, which leaves the lipid, which is referred to as a crude oil. So just to summarise, in this Martek DASCO process, you burst the cells mechanically and use a non-polar solvent, truly a solvent as regards the lipid, because it dissolves in it, which you can then separate and evaporate off. There is another CGK process called the Free-Elex process, which emerged from the plant or seed oil production context as well. And my lords will see that described at paragraph 128 on page 175. And in this case, it's not using any chemical to dissolve the lipid like the hexane process did. What it actually does is affect the degree to which the water phase is polar by adding a polar chemical to mix in with the water. So it's typically called a polar solvent, and a typical one would be isopropanol. But as I've said, you don't dissolve the lipid in that. It's going into the other phase, into the water, mixing with it, and making that more polar, and therefore more separable from the oil. And so in this technique, one starts with an aqueous mixture containing the cells. Again, you obviously have to lyse them one way or another, so the contents, including the oil, are released. And when one's done that, we've got a water and lipid mixture, which would likely be an emulsion. And then we treat that with isopropanol or some other polar solvent, mix it, and then centrifuge it to separate the phases. And they're more likely to separate because of that increased polarity. And you'll see that point made about 6 lines into paragraph 128 makes the water miscible isopropanol, makes the aqueous phase more polar. The point to mention here, 6 lines from the end, is a further detail that was possible, and that's to add salt. And that increases the density of the already more dense water isopropanol phase. And so the effect of the centrifuge, which obviously works on density difference between the water phase with the isopropanol and the lighter oil phase, that density difference is amplified, so the effect of the centrifuge is amplified. So separation is further encouraged. So, Lords, that's the Free-Elex process in a nutshell, with or without salt also added. And adding the salt was also a CGK technique. Now, my lords, over the page, just to go back to the pre-Alex and hexane processes, you've got a helpful illustration of the difference between them. You've got hexane in blue at the top, pre-Alex in red underneath. And you can see at both of them there's a centrifuge step where the arrow splits. In pre-Alex, you're centrifuging the crude oil off from water, solvent and the debris. And in the hexane process, you're getting residual water and debris, and you're not left with crude oil. At that point, you've got hexane within which the oil is dissolved. But that is a helpful summary that the judge gave. Now, my lords, these processes are obviously not specific to particular cells. And the next thing in the common general knowledge to pick up is on the microorganisms that might be used. As I think I've already said, this particular process, the Martech Dasco oil, was derived from C. coni, and so that was one well-known source of DHA containing lipids, but there are others. And of interest for us are the Schizochytrium microorganisms. And to just pick that up, can you skip forward please to page 178? Paragraph 142 is where the judge addresses this. And it's addressing a group of microorganisms. Schizochytrium identifies a group. And the reason this is important for my lords is because this is the only detail in the 155 claim not expressly identified in the bile prior art. And paragraph 142 identifies an individual called Bill Barclay as a prominent figure in the field, his company and its patents as being a source of information about thrustochytrids, which is a broader category which includes Schizochytrium. And paragraph 143 specifically calls out the particular strain, HTCC 20888, which had been deposited and which was the source for its DHA oil. And it was not as big sales-wise as Martech's product, but it was nonetheless notable in terms of sales. And the strain was well known in 2002 as a good source of DHA. That's paragraphs 144 and 145, and the latter referring to the coverage of it in the single cell oils textbook. So that was a common general knowledge cell that you might want to use, and in fact it's more than that, because Barclay's strain was in fact advantageous to use, particularly over C. coni. Paragraphs 146 and 147 are important on that. There was no dispute at trial as to whether that was in fact so, but there was a dispute as to whether those advantages were common general knowledge in 2002 or only became so later by the next relevant date that we had, which was 2009. Our case was that these were CGK in 2002, and as the judge records here in paragraph 146, DSM's expert, Dr. Wynne, confirmed our position in cross-examination. And the actual advantages are identified in paragraph 147. The first is low salinity. As I've mentioned, these microorganisms are sea-dwelling, and an ability to grow them in low salinity conditions is a significant advantage when you want to use stainless steel, because it's an issue with corrosion of your equipment. So lower salinity is better, and there are two other advantages, the second and third there, paragraphs little 2 and 3 of 147, both relate to the efficiency of growth compared to C. coni. So my lords have the point. Barclay's strain was very attractive to use for DHA production and indeed advantageous over C. coni. Now the next topic that I wanted to just pick up with my lords is that of enzymatic lysis itself, and the judge has foreshadowed his findings on this earlier on in the CGK section, but let's look where he dealt with it in his skilled team section. But let's look where he deals with it in the in the CGK section. So it's paragraph 154 where he turns to this. So that's on page 181. And what he does is he sets out at some length the evidence, including the written evidence of both of my friend's experts. That's through pages all the way through 182 and 183. And right at the bottom of 183, so I'm looking at paragraph 163, see, immediately after that, he says that the cross-examination revealed a somewhat different picture. And he explained that whilst they both made it clear brute force methods, homogenisation and the bead milling were used in commercial production, Mr. Dweppen accepted that the skilled team knew there were other methods, and the cross-examination was set out at the top of page 184. And one sees in the answer that's set out there that he's accepting not only that they were known, but they were particularly useful for smaller scale benchtop, reflecting the judge's holding earlier as to smaller scale in laboratories, in industry and academia. Now, my lords see what my expert, Dr. Kyle, had said in the first sentence of 164, so moving on, and in the second sentence, the judge went on to explain that enzymatic lysis was, the fact that it was CGK was reflected in a number of documents, and he identifies 3. And one of them, the first listed, was that single cell oils text that we'd been using as a source of CGK that Dr. Kyle had drawn attention to as the previous sentence had explained. So I'm labouring this point a little bit because of the way in which my friend Skeleton suggests the judge didn't really find it was common general knowledge. The upshot is really 166. It was common general knowledge, but as the judge said here, it was another matter as to how the skilled person would approach the suggestion to use it, and that was context dependent. Just for completeness, my lords, the single cell textbook, we've set out that extract at paragraph little 8 at the foot of page 5 of our 155 skeleton, and the passage we draw attention to is over the page on page 6. And we give, my lords, the reference there so there's no confusion. Where it says biological there, that it's all agreed by my friends experts that meant enzymatic. So biological in that context means enzymatic. So, my lords, that's a bit of a whistle-stop tour of the key bits of common general knowledge for your understanding of the arguments on this appeal. Can I turn to the 155 patent itself, please? It's in the supplementary bundle, the first one, tab 1. And I'm going to deal with it as briefly as I can, because of course what matters for an obviousness case is what is obvious to do absent the knowledge of the patent. So in a sense my case only really depends upon what's obvious, and we need to look at this patent to know whether it's within its claim or not. So can I jump straight to the claim in suit? I want to start with that if I may. So if you go to page 9 of this bundle, 7 of the document, we concern with claim 1. You can see the claim is a method claim, and it's a method for obtaining a polyunsaturated fatty acid containing lipid. And you can see there are 3 steps that are required. They're listed after the words comprising. And because the word comprising is there, that means other steps may or may not be present, but the claim covers all methods that have these steps. And the steps are first providing a biomass which comprises microorganisms of the genus Schizochytrium, which biomass containing a polyunsaturated containing fatty acid. Second, this is B, contacting the biomass with an enzyme, and third, recovering the lipid. And the final limitation after the steps, so where the word wherein, is the contacting with an enzyme comprises treating with a protease. And a protease is a particular type of enzyme. It's a category of enzymes basically those which digest proteins. So in essence, my lords, the claim is to a method of extracting a PUFA lipid.
Is this a two-part claim? It's not expressed explicitly in two-part form, but you could read it as such, wherein...
You mean a two-part in the sense of the really clever bits identified?
Characterised in that.
Yeah, you could. I don't think anybody... Well, certainly on the judge's finding, that can't be so, because the identity of an appropriate enzyme is straightforward once you've decided to use an enzyme. Sometimes the where-ins are added in just to restrict the scope of the claim later on, as my lord knows.
Yeah.
So you can't. I wouldn't want to suggest you should go one way or another on that.
Okay.
In essence, it's to a method of extracting a PUFA lipid from schizocytrium cells where a protease enzyme is used to lyse the cells so that one can get at the lipid that they contain. So any method to produce a polyunsaturated lipid from any schizocytrium cell, for example, Barclay's well-known strain, is within the claim if enzymatic lysis is used where it's a protease. And in terms of what we've seen in the common general knowledge, the claim is to use of schizocytrium. As I've already emphasised, at least some of those were well known to be useful as a source of polyunsaturated fatty acid lipids. In particular, that strain, the 2O-888 strain, an attractive source for DHA, and known to have those advantages that I drew my lord's attention to over another known cell that was used, C. coni. Secondly, in terms of what we've seen in the CGK, the use of enzymatic lysis. Of course, this is specific to protease. So it's the CGK method that has been used and explored at small-scale labs in both industry and academia, and covered in the single-cell oils text. Now, I ought to just pick up on a few details of the disclosure itself. For my lord's note, I wasn't going to go through what the judge said about all of it, but he deals with it at paragraphs 214 to 246 of the judgment. Can I just highlight a couple of aspects of the disclosure of the body of the document, looking at it in tab 1 of this bundle? And so I'm going back to the beginning of the text. And the first thing I want to draw attention to is the problem said to exist with the prior methods at para 3, so I'm on supplementary bundle page 4. And they're said to be poor quality if chemically aggressive conditions of high temperature and high pH are used. And it goes on in that paragraph. Additionally, it says problem is the high cost due to the need to dry the biomass or for additional equipment such as homogenizers and pressure vessels. So at least part of it, the problem, is the additional costs of the additional equipment needed for the brute force method of mechanical lysing. The next thing to pick up is the assertion at paragraph 21, so I'm over the page towards the foot of bundle page 5, that the use of a protease can help break down emulsion stabilising proteins present, aiding breaking of an emulsion, and the further assertion is made here that it's surprising that protease would liberate a lipid from microalgae because it's said here they tend to have low protein content. That in terms of a surprise, didn't survive the judge's findings. And I'm drawing attention to it here because it's also, as you know, the Kobzev prior art is the prior art, which is basically this disclosure when we come to the next one. So I'm just giving my lords everything that may be relevant about this disclosure in one go, as it were. The thing to note here is what's surprising is said to reside in the identity of the enzyme, it being a protease. not that enzymatic lysis per se works. And I think my lords may have picked up that the judge held the skilled team would know in general there were three main components of a cell wall and membrane, and those are carbohydrate, protein and lipid, paragraph 150 of the judgment, and they would know at least of the order 15 to 22% would be protein without even looking up a specific cell type. And it also held that if a skilled team was interested in enzymatic lysis, they might look up the cell wall composition, but more likely they'd just do a simple and routine empirical test in the lab and they'd find out which enzymes would work. That's his paragraph 153. So in terms of identity of which ones work, the judge wasn't making findings that would have been impressed by that. So the 2 points that I invite my lords to grasp here. First, that point, that what's being put forward, the surprise about protease, is not the basis of the judge's decision on inventiveness. Indeed, the conclusions in the paragraphs I just referred to are to the contrary effect. And the second point I draw attention to is that it's not said that protease gives any particular advantage as to lysis either. Any enzyme that digests a component that's present in the cell wall in a significant quantity would be just as good at achieving lysis. Now, my lords, can we return to my brief explanation of 155's disclosure and pick it up at paragraph 25? This is page 6 of the bundle. It identifies two preferable Schizachytrium strains, and you'll see...
Can you give me the page again?
Sorry, supplementary 6,
Thank you.
paragraph 25 at the top.
Yes.
And the key thing I want my lord to see is the magic number 20888 in line 13.
Is
So
the
that
underlining in the original, and if so, do I take it that we ignore it?
I think it is in the original, and nobody's made anything of it. I think we have all ignored it. It doesn't seem to emphasise anything.
Yeah.
But
Just typographical.
I think so, yes.
Thank you.
But one of the two I've identified is that very attractive common general knowledge Berkeley strain. At the foot of page 6, so paragraph 29, we see in the third and fourth main bullets that there may be an emulsion formed, and one may choose to have additional treatment, for example, the use of polar solvent, salt, heating. But it's certainly not put forward as inevitable, although the example, as we'll see, did use a polar solvent. Now, in fact, there are 3 examples, but the first 2 are just tests on the degree of lysis seen with particular enzymes with and without surfactants. So there's only one that actually does the whole thing, getting the oil out. That's example 3, and it's set out at paragraph 44 on page 9 of the bundle. And the key things here are point 4 is the addition of a protease. That's what alkalase is in the 4th bullet point. That's the protease. So that's the lysis step. And the third to last point is the addition of isopropanol before centrifuging. So that's the free Alex idea, polar solvent treatment that I just mentioned is happening. Unfortunately, the comparison in the table at paragraph 46 is not against the same method with a different method of lysing the cells. And the table compares peroxide and, I always get this word wrong, anisidine value. Those are both indicators of quality of the oil, and they're comparing that against hexane extraction using ball milling. So you can't tell what causes the improved value, but there is a table there making that comparison. That's all I wanted to show, my lords, on the patent itself. Can I turn to the prior art, which is bile, which, as my lords know, is also a DSM document, And you'll find that at tab 3 in this same bundle. And just for my Lord's note, the judge's commentary on this is from paragraph 176 on page 186 through to para 192 on para 213 on page 192. I'm going to look at the document itself, and before we get into the main body of it, it's worth looking at the front page of Bile, please. So that's page 124. This is the abstract between the hole punches. So it's how bile itself describes its essence. And it describes its disclosure thus: extraction of a microbial or single cell oil, for example, comprising one or more polyunsaturated acids, PUFAs, directly from microbial cells is disclosed, which avoids the need for solvents. After fermentation, the microbial cells are pasteurised, washed, and the cell walls lysed or disrupted by a mechanical, e.g. homogenization, physical, boiling or drying, chemical, solvents, or enzymatic cell wall degrading enzymes technique. The oil containing the PUFA is then separated from the resulting cell wall debris. This is achieved by centrifugation, which results in an oil phase top layer that contains the oil, which can be separated from the aqueous phase containing the cell wall debris. The oil can then be extracted, and if necessary, the PUFA can be purified or isolated from the oil. So, just pausing there, my lords, a couple of things to note. It doesn't mention here the use of any particular cell. It's a disclosure as to a general method of extracting oil from microbes or single cell oils. Of course, when we get to the specific examples, it has to tell you what they've done. It doesn't here suggest that it's specific to any cell. And the reason I'm emphasising that point is the judge, as I've already said, held that using Barclay's strain was attractive and had particular advantages. And it's the only thing that's not mentioned in this document that is necessary to hit claim 1 of the 155 patent. The second thing to note is that the abstract itself focuses on the means that may be used to lyse or disrupt the cell walls. In describing its very essence, it identifies the options. It includes homogenization, but also 3 other methods, specifically including the enzymatic technique as an option. And to be absolutely clear, it was a CGK method, to be sure, but my case is advanced on the basis that the document itself tells the reader they can use it. And of course you see it referred to again and again in the main body, but it's telling you, even in describing its very essence, that this is a method. Now the third and final point I draw attention to at this point is that the document refers to a method which avoids the need for solvents, but one can see that it's not contemplating absence as an absolute necessity, because it expressly mentions that solvents as the chemical means by which lysis may be affected. And as we shall see, the way it's put in the main body is that the method it's disclosing has an advantage that you can avoid the need for solvents. And no doubt when it comes to the chemical lysing method, it explains that that's not preferred. Now, can I pick up a few key aspects of the disclosure? So if we go over to bundle page 125, paragraphs 3 and 4 refer to the way in which most production processes proceeded. And the focus here is on the hexane extraction process, and in particular in paragraph 4, the cost for its removal, which must be complete. In paragraph 3, they'd also referred to the degradation of lipids. That's about line 24. And this document talks about the art teaching that to avoid oxidization of the lipids, such as happens when the cells are broken open, when you're exposed to oxygen, you can extract from intact cells using a solvent. So that's focusing on a method where the solvent dissolves the lipid and then moves out of the whole cell without breaking it open. Now, what is absolutely clear is right at the end of paragraph 4, it ends by stating, with increased environmental considerations, the use of solvents for the extraction of lipids is becoming increasingly expensive and unpopular. So it's definitely flagging up that what they're proposing is something where you can avoid the use of solvents. Now, paragraph 6 sets out what is referred to as a first aspect of the invention. And that is, in essence, what we saw in the abstract, but even more concise because the specific options for lysis are not expressly set out here. So that's paragraph 6, right at the foot of column 1. It simply says it's a process comprising lysing the cells to release the oil so that they can be separated from part of the cell wall debris, and the oil can then be recovered, purified or isolated. My lords should note the end of paragraph 6 states that a good yield can be achieved without the need for a solvent. So again, it's emphasising what can be achieved without also using a solvent. And paragraph 7 is back to talking about the other methods which keep the cells intact. Now, paragraph 8 is where we've moved to a section on PUFAs and microorganisms, and it identifies several well-known microbes as sources of PUFAs, and as I've already emphasised, Schizochytrium are not mentioned here. So my lord should note that. The next thing to pick up is paragraph 14, under the heading lysis. The cell walls can be disrupted or lysed using one or more enzymatic, physical or mechanical methods or techniques, for example, high shear conditions. And after that paragraph with the general introduction, the first technique dealt with in more detail at paragraph 15 is the enzymatic technique. And it explains it includes lysis by one or more enzymes, e.g. cell wall degradation enzymes. And we see at line 31, proteases is included. And I think I'm right that our skeleton sets out that key text in our paragraph 21. Now, paragraph 16 deals with the mechanical techniques, which is where we see the homogenizers and bead mills referred to. And 17 mentions that homogenization is the preferred method of disrupting the cell walls. My lord should know 18.2, as it deals with the fourth type, chemical, that which was identified as using a solvent, but says this is not preferable, not employed, as the process is desirably solvent-free. So it's actually telling you four methods. One's preferable, and one's definitely not preferable, so there are only two others other than the preferable mechanical one. Now, the next section, starting at paragraph 21, is headed Separation of the oil from the cell debris. And what's described here, particularly paragraph 24, is separation achieved by centrifugation, with details of suitable machines and G-forces to be achieved. Those are described in 22 as well. 24 so the bottom of the page over to the top of the next page, addresses two things can be preferably avoided. 24 deals with solvents, so we've already seen that, preferable to avoid them. And what's explained is that one advantage of the process is that you can avoid the need for solvents. And I'm now at the top of column 5, on page 127 of the bundle, one line down. Thus, no, e.g. organic solvent may be employed either in the stage of disrupting the cell walls or in the separation of at least part of the cell debris. And it goes on and explains that preferably no, e.g. organic solvent is used either in the extraction, purification or isolation of the oil or one or more PUFAs. Thus, in essence, the process is solvent-free. Thus, stages A, B, C and optionally C can be performed without, e.g. an organic solvent. Just to be absolutely clear, when it refers to stages A, B, C there, those are identified in paragraph 6, the A, B and C. And they're the things that I've just read out, but just so that you know that's where those numbering comes from. So it's saying it can be performed with a solvent, but can also be an advantage is it can be performed without. And that's no doubt why the chemical lysis is not preferred. Now, paragraph 25 refers to something else that can be avoided, surfactants. And the guts of it is the same in that each or both of the disruption and separation stages can be performed without the need of surfactants. In fact, if we go back to the method that can be performed earlier back in 21, although it's preferable not to, you see right at the end of 21, the disclosure expressly stated that you can have them. So it's just telling you that in this document that one of the advantages is that you may be able to avoid it. Now, the overall protocol is summarised at paragraph 28. And can we look at this, please? It's more detailed than the very general description. It's expressly a preferred process. You see that in the first words of 28, about halfway through column 5. And points to note here, for my lords, are step E is the lysing in this preferred process. And it says it's done, for example, this is line 45, by a physical, enzymatic or mechanical technique. The latter of which is identified by way of example in brackets homogenization. Line 49 also explains that mechanical disruption may be supplemented with or substituted with chemical and or enzymatic disruption. So that's lysing. Separation, this is step F, and it may comprise centrifugation. That's the penultimate line of column 5. And it's here the document specifically states that this may be done optionally with the addition of one or more salts. So that's the CGK technique that I identified, line 59 of column 5. But it also goes on to mention pH shift towards alkaline too. Now that's a method that was not CGK in 2002, but we know works because it's the subject of the 801 patent. So it's another thing that this document is telling you can do to aid the centrifugation to achieve separation. Now there are two specific examples. Both use homogenization, as my lords know, as the method of lysis, followed by simple centrifugation to cause separation into an oily top layer and a lower aqueous layer containing cell debris. So they don't deploy any of the additional things which may assist if you have difficulty. They say it's just centrifugation. As for the microbes that are specifically used in these examples, the first is carried out with a cell called M. alpine, and the second is C. coni. So that is the disclosure of the prior art bile. Can I now turn to the nub of the issues, the decision on obviousness? And the first thing I want to do is to identify the scope of the argument before my lords. You will have seen that we address the judge's 4 points that he gives. We address those in our skeleton, and in fact we also dealt with respondent's notice points that my friend had included in a respondent's notice. And we deal with that in our skeleton at paragraphs 32 to 53 on the judge's 4 points, and paragraph 62 onwards on the respondent's notice points. Now, in their responsive skeleton, 155, my friend also advances 2 points of criticism as to our case in our skeleton. And I want to identify those for my lords because they are identified on pages 2 and 3 of that document, and they are, we say, Aunt Sally's. In the first, they seek to say that the judge did not really find enzymatic lysis as part of the CGK in the field of single-cell oil production. And they build on that to suggest the skilled team wouldn't know what microbes could be lysed with what enzymes, and so on. Now that's completely inconsistent with the judge's conclusions that I've shown you, that it was used and explored on a small scale in the lab, which is where new processes are developed. That's his paragraph 45. And those paragraphs I showed you where he explained how the enzymes were identified. So that's the first point. The second, which is made from paragraph 11 onwards, is a suggestion that we argue that it was common general knowledge that a weaker emulsion would be formed by enzymatic lysis. And here, it's important to understand that our case is not that, and there's an important distinction that I want to make sure that my lords grasp between something that a skilled person already knows or thinks as part of their common general knowledge, i.e. it's in their mind before they pick up a piece of prior art, in the hypothetical exercise that we have to do, and something which they think or perceive as they read and take in the technical disclosure of a piece of prior art. Our case is the latter. Now, there is also, it's convenient here to pause to identify a second important point for my lords to grasp in relation to this issue. The words my friend uses in his paragraph 11 on page 3 of his 155 skeleton are weaker emulsions. I think elsewhere one might see us or perhaps the judge referring to gentler. And the point I want to make sure that my lords have in mind, and I'm drawing attention to, is this. This is a point about comparison. Weaker than what? Weaker or gentler than that formed when the cells are homogenized, when they've had the living daylights beaten out of them. And why am I making this point? Because the point to grasp is that means that you are referring to the same relative comparison as to strength or weakness of emulsion if you talk about enzymatic lysis leading to a weaker emulsion, as you are when you speak about homogenization tending to be or lead to a stronger emulsion. They're two sides of the same coin. And as to the point being made in my friend's paragraph 11 onwards, as I've already said, it's not my case that the skilled person already has in their head an abstract piece of common general knowledge before they pick up bile and read it. It's my case that when they read it and the question of the strength of the emulsion that arises pops up in their mind because they're worried about it, which is common ground it would, they also appreciate that the emulsions which would likely result from the different method of lysis would likely not be the same with enzymatic, because they don't whack the cells violently, likely having a weaker or gentler resulting emulsion. And as I say, it's the same thing if that's expressed as homogenization leading to a stronger emulsion. And it's my case that that is what the skilled person appreciates when they read bile, turn their mind to it. It's not an argument about CGK, as my friend says. And just to be absolutely clear, the point that I've articulated was actually how my friend's experts put it too. Not part of the pre-existing CGK in their mind before they read the document, but how the skilled reader would view things on reading it and thinking about the emulsion. And just to be clear, Mr. Dweppen and Dr. Wynne didn't put it in terms of the emulsion being weaker with enzymes. They focused on using homogenization, and they used the other side of that same coin and referred to the skilled person perceiving the emulsion to be particularly hard to break due to the high energy of the homogenization. And let me just show you that. So you need the supplementary bundle, first one. And we want to go to tab 8. So I'm in bundle 239. Paragraph 36. This is Mr. Dweppen, who, this is his second report. This was actually dealt with by Dr. Wynne in his main report. I'll come to that, but Mr. Dweppen picked it up in his second report. And here, in paragraph 36, he's talking about emulsions and what the skilled bioprocessing engineer would appreciate about them. See the third line down in paragraph 36. And he goes on discussing separation just by gravity, works for salad dressing emulsions but not mayonnaise. And he went on in the sentence bridging the page to say emulsions in microbial are very stable due to a host of compounds, e.g. protein. And then at the top of page 240, certain processes can cause vigorous mixing, e.g. homogenization creates even stronger emulsion. So what he's saying is that the emulsions in microbial oils are very stable, and if you're using homogenization, it's going to be even stronger. Dr. Wynne, tab 11, bundle page 356. This is specifically addressing the examples in bile. I'm on paragraph 159 on page 356. He says, in this case from the skilled microbiologist's view, that was the other member of the team in the way they sought to split it. My lords will recall that they split their team into two and tried to argue they didn't speak to each other. So this was from the skilled microbiologist's view. He goes on to say that they would find the results very surprising. This is the bile results, as it's well known when lipids and water were mixed, particularly under high turbulence conditions, such as those in homogenizer, it's likely an emulsion would form. And we'll be coming back to this to see how this develops in cross-examination when we get to the judge's fourth point. But what they're saying, they're using the other side of the coin, as I've said, but they are drawing particular attention to the fact that the skilled team, when looking at bile, would have a particular concern if high turbulence conditions were used, i.e. homogenise it. I should just say why we're on this. The judge actually accepted this in his judgment and found skilled team reading bile would perceive this. Can I show you 274? So I'm back in the judgment. This is where the judge is talking about the perception that bile would be considered somewhat strange. Not enough to decide not to pursue it, mind, it was common ground they would. But one of the points he explained, subpara 3, includes this point, right at the end. The reference to the problem of breaking the emulsion that would form, and please note this well, particularly if mechanical methods of lysis were used. And the point I make here is this is no different to how my friends experts were approaching it. The skilled team, when reading bile, does turn their mind to the emulsion and how likely this would turn out to be very strong. In particular, they would have in mind that the method of lysis would matter and appreciate it would be stronger with homogenisation than others. In any event, my case is that this is a perception as you read bile. It's not a CGK point before bile's even picked up. That's a second Aunt Sally in my friend's skeleton. Now, my lords, my case was and remains very simple, and it's this. Anyone seeking to develop microbial oil process would be interested in using Berkeley's well-known strain with its advantages. And using bile's teaching with that strain was very obvious. And as I've said more than once now, I think, that is the only thing not expressly set out in bile, that particular strain. And I also say one of the obvious things to do as regards the lysis of cells is one of the very things set out in bile, including being called out in its short abstract, enzymatic lysis. That really is it. Now, the judge at paragraph 285 broke it down into smaller chunks he called steps. But they're not the kind of self-contained steps that give rise to technograph arguments, and it's important that my lords understand that. For example, one can't decide to use enzymatic lysis without choosing an appropriate enzyme. And it's not another technograph step to then use what one's just chosen as the enzyme. So those three things are steps 2, 3, and 4. Nor can one suggest that separation of the PUFA, which is his step 5, can that be a choice to do or not to do? One has to do that. And the judge held that it could be done, and it didn't stand in the way of an obviousness finding, as he said at 286, immediately under these steps. So, my lords, things really do boil down to just those 2 points I identified, which are in fact the judge's first 2 steps. The very obvious cell strain, which is advantageous and well known, and the enzymatic option for lysis expressly identified in bile itself. And my lords, I think, will have picked up that the judge had no difficulty with anything other than the decision to use enzymatic lysis. Everything else in his breakdown was obvious, the use of the cells, And if enzymatic lysis was used, the choice of a protease as an appropriate enzyme by an obvious simple lab test, either with or without literature search, that was all obvious. But the issue, the only issue, was whether that which Bile called out as an option, enzymatic lysis, was an obvious thing to do. And can I just pause and emphasise this? An obvious thing to do. Because it merely needs to be one of the obvious things, not the most obvious thing. And the judge said this was a reasonably finely balanced issue. Can I show my lords that? So page 209. Right at the foot of the page, paragraph 316. And it comes immediately after he's given 4 points in paragraph 311 to 314 for concluding the obviousness case as to using enzymatic lysis in the light of bile involved hindsight and therefore was not obvious. So the judge thought it was reasonably finely balanced, but he found against me. And before I look at the reasons he gave for concluding that it involved hindsight, can I just pause and make a point? None of what we are going to look at has anything to do with the characteristics of a particular cell line. And what I mean by that is that really this is an argument that the skilled team seeking to take bile teaching forward, whatever the cell line they were interested in, would find it not obvious to look at enzymatic lysis, even though it's called out as one of the 3 options for lysis, or 4 if you include the additional chemical method it deprecates. That's what the essence of the argument is. It's that simple, because it's nothing to do with the cell line. Nobody implementing bile would think of enzymatic lysis, even though it's there. Now let's look at what the judge gave us his 4 points. So I'm in paragraphs 311 down to 314. The first, this is paragraph 311, is our case was not significantly different to one over common general knowledge. And he also suggested that we were discarding the rest of the bile teaching. Now, my friends in their response say the reference to discarding the rest of bile teaching is important context for what the judge said about the case not being any different to one based on CGK. And they suggest we haven't dealt with it. This is paragraphs 30 to 31 in their skeleton. So let me meet that head on. My submission is there's no teaching in bile that we're discarding unless, of course, you consider adopting one option put forward amounts to discarding the other options put forward. But that's the whole point of putting forward more than one option. And of course, if one were to select one option, you're not going to do the other, or at least not at the point in time you're doing the one you've selected. And one could say you're discarding the teaching in the same way if you elected to do one example but not another in a pattern. That isn't what we normally talk about in patent law, about discarding the teaching of bile. Now, my lord, the judge's suggestion that our case is no different to one over CGK is also not well made. The fact that enzymatic lysis is a CGK technique doesn't make my case worse than it would be, nor akin to a CGK only case. I think I've already said this, but my case is rooted in the fact that bile discloses it as an option. And we draw attention to a few of the places it's referred to in the body of bile in our paragraph 33, even included in claim 2 of bile, enzymatic lysis. And I showed you an additional place in the abstract earlier too, where it's part of the short text describing its own essence. And my Lord Justice Arnold knows well, the point about CGK alone cases is there's a danger one's plucking something from the CGK when there may be no prompt to make the skilled person think of it. And that's simply not the case here. The document, the fact that it's CGK, helps in that everyone knows it, it's not an outlandish method, but it's actually being called out by the document itself. In other words, bile places enzymatic lysis firmly on the agenda by identifying it as an option. And most importantly, it requires absolutely no hindsight to read it and consider enzymatic lysis. And as we go a little bit further in our criticism of this reason given by the judge, because he didn't explain why he took the comparison with CGK alone, a case based on CGK alone, against Mara. And for the reasons I've just given, it's not an apt concern. The usual concern is that actually it's hindsight to identify it. And particularly if you're going to be combining it with a document that doesn't identify it, which may have other distractions or misdirections. Now, my lords, my friends also seek to defend this first reason in their skeleton by saying it forms the foundation for subsequent paragraphs. Now, my submission about that is it doesn't turn a bad point into a good point. Indeed, it goes to vitiate any further point that's built on it. We also see my friend advance 5 sub-points to meet our submission that the case was firmly rooted in bile. This is their paragraph 34. So I'm on page 9 of his skeleton. And the first point needs to be treated with some care in my submission, as it's possible it might mislead my lords, and I'm going to come back to look at that in detail. But before I do that, can we deal with the others more quickly? The thrust of them is to repeat the point that enzymatic lysis was not used in one of the 2 examples that mechanical lysis was preferred in those and expressly identified as preferred in the document. That's the thrust of subpara B. It is again the thrust of subpara E. Subpara C is a similar point on the microbes and the fact that Schizochytrium is not included in those. But that doesn't help my friends, as Berkeley's well-known strain was very attractive. And there's nothing in subparagraph D either. This is the identification of a suitable enzyme, ascertaining whether a protease or a carbohydrase would work or both by a simple test. And just as an aside, the literature search is but one thing that the skilled team might do, but it's not the basis for the judge's finding. The basis was the simple test. Looking it up in the literature is just another string to the bow, and it may or may not be looked up rather than doing the test if convenient. So there's nothing in those 4 paragraphs. My lord, that leaves subparagraph A. And you need to understand the difference between a suggestion that one does not use a solvent, so no chemical which is a solvent added even at the end to dissolve the oil like hexane or a pre-Alex type solvent. You need to understand the difference between that and a suggestion that one's being taught to use centrifugation alone. In all of these kinds of cases, whether with or without solvents, one's contemplating centrifuging. And Biles teaching is a method where one can avoid a solvent, but it is simply not teaching of centrifugation alone without other ways to assist, such as salt. Nor did the judge characterise it like that in the paragraphs my friends refer to in this subparagraph A. Paragraphs 277, 312 are referring to centrifugation without solvent, but not without any other technique. Let's take 312 first, because it's on the very page that we're looking at. We see the judge refers to a solventless separation step using centrifugation with the optional addition of salts. That's not saying it must be centrifugation alone, as my friends suggest in paragraph 34A. In fact, you'll recall the overall protocol setting out the detail of the preferred process immediately before the specific examples actually identified other techniques that could be used as well. So it's not just salts, but that's not what the judge is referring to, centrifugation alone here. Can we pick up the other paragraph where it suggests that the judge is holding that Biles is teaching to use centrifugation alone? That's paragraph 277. So we're on core bundle page 202, Bridges page 202 goes over to the top of 203.
Does this point really add up to very much?
Well, other than
If they added in the words centrifugation plus salts in their skeleton.
and
The point they're making is a different one, isn't it? Which is that it wasn't a point about the method of lysis, which is what you're saying the skill team would have picked up on.
yes, but the reason it's potentially important is because there's a suggestion that you can't get centrifugation alone to work. And the teaching of Biles is not centrifugation alone. It's definitely centrifugation without solvent. But there are these other methods that we in fact know work, and the judge held it would work. And so I understand the point that my lord's making to me. I just thought it was important that the teaching is not centrifugation alone, and that is actually important, part of the judge's finding as to how you would do it and the fact that it would work. But I take my judge's hint and move on. I've made the point that those paragraphs are not
Centrifugation plus,
for instance, those things that we saw in the overall process. And my point really doesn't get any better by repeating that there's a difference between centrifugation without solvent, which may have other things, and saying centrifugation alone. Because, of course, the examples do have only centrifugation. And the point I was going to make on 277 is that the judge refers to the teaching at the bottom of page 202, centrifugation and without a solvent. So it's not centrifugation alone, it's the point about not with a solvent. And the only time you see centrifugation alone referred to is a reference to the examples later on, which of course those examples are, but that's not the scope of the teaching. Before I move on to the second point, I can't resist just drawing attention to the fact that on this first point, as to my case being akin to a CGK alone case, which my friend seeks to support the judge on, I draw attention to the fact that he's at the same time saying that the judge didn't really find enzymatic lysis to be CGK. So he's at the same time saying that it isn't really CGK, but then the judge was correct in treating it as if it was a CGK-only case. So there's a tension there in the submissions that he's making. So that's the first point. And the real guts of it is there is a big difference between a CGK alone case and where the thing is called out in the document that you're relying upon. The second point is paragraph 312, and it's related to the points that we've just been discussing. And that's where the judge says that what's new in bile is not the mention of the CGK methods of lysis, but the suggestion of separation without a solvent using centrifugation. Here the judge says, with the option of one or more salts, but in fact, for your note, he recognised the disclosure went broader in the way that I've just been addressing, when he dealt with the disclosure in detail, for example, paragraphs 202 to 204, paragraph 204 in particular. So the judge's second point is to state that what was new in bile was demonstrated in two examples, each of which featured mechanical lysis. And that, of course, is true. It was. And so the essence of the point is neither of the examples use enzymatic lysis. They used homogenization. That's true. But that doesn't, in my submission, negate that enzymatic lysis is explicitly taught as an alternative. And as I think I've said already, it's trite law we're concerned with what is obvious, of which several things may be, not what is the most obvious. And we go further and make a point about this in paragraph 41 of our skeleton that's pertinent to perhaps the key point, which is the judge's fourth point that we'll be coming on to, is that any concerns about the examples, centrifugation without the other assisting features and homogenization, particularly homogenization, would drive the skilled person to consider enzymatic lysis, as the emulsion problem wouldn't be so great. Now, my friends suggest that the point the judge is making here is actually different. This is their paragraph 36 of their skeleton. They say that bile points the skilled team in a different direction. And they characterise their suggestion by saying our case is to focus on investigating something else rather than simply use the demulsification step in bile. That's not really fair as a submission, my lords. We're not suggesting something other than to use enzymatic lysis, the option called out in bile. And when we get to the fourth point, you'll see we say there's a jolly good reason to do it. And all the rest is the same. And in any event, the judge held the separation ground didn't stand in the way of the obviousness finding, as I showed you earlier. My friends make a further point in their paragraph 37, seeking to make a virtue out of the judge's findings that the examples using homogenization and centrifugation without the other techniques identified in bile as assisting on the emulsion issue wouldn't achieve any substantial separation. Now, my lords, that is a very double-edged sword for my friends, because you will see when we get to point 4, which is really the key point. There is evidence on the point that the judge said wasn't there, and it pushes the skilled team to enzymes. Because when they read bile and think about and worry about the emulsion issue, they appreciate the emulsion issue will be a lesser issue with enzymes. Now, my lords, the third point the judge makes is paragraph 313. This is the why was it not done before point. We say in paragraph 43 of our skeleton, the error here is similar to the judge treating our case as akin to a CGK alone case. Bile proposed a solvent-free extraction method, which was common ground the skilled team would want to take forward. And as we explain further in paragraph 44, the interest arises from the context of the document itself, what it's proposing. And its publication was less than 3 months before the priority document. In fact, we'd no evidence that it would have come to anyone's
Sorry,
notice.
when you say the interest in enzymatic lysis arises from the context of bile, can you
No.
explain what you
Yeah,
mean?
I didn't. I meant the interest in taking forward a solventless process which it was disclosing. So the interest in taking bile forward. I apologise if my lord thought I was saying the specific interest in lysis came from that. But the interest in taking that teaching forward arises because they're telling you about solventless process, and then you think about how you take it forward, and lysis is one of the things it calls out.
Well, I'm a bit puzzled by that submission because there seem to be two different questions in play. One is interest in developing a solvent-free process, that's one thing. But that isn't what the judge is talking about in 313, is it? Doesn't refer to interest in solvent-free process. He's talking about enzymatic lysis.
Yeah, my lord's right. As a CGK process itself, the point that I'm making is that the interest for, let me break it down in stages. The interest in enzymatic lysis arises in the context of bile because of what it's proposing in terms of being able to achieve solventless. And one of the things you see there is the suggestion that you can do it enzymatically. And that obviously doesn't arise until bile has been published. Which was just a few months earlier, and there's actually no evidence that bile itself would have been seen even in those few months. But just...
Well, I'm grateful for that explanation. Can I just clarify? Is it your case the skilled team reading bile would perceive that enzymatic lysis is advantageous over the other methods suggested in bile because it leads to a solvent-free process?
Not because it leads to it. Bile, although bile obviously contemplates that you can use its method with a solvent, it's telling you that's the key advantage that you can get. What I'm saying to my lords is asking yourself why wasn't enzymatic lysis done in the abstract, which might be a question you would ask on a CGO alone case, is not the right question here. The interest in doing something at all is because bile has proposed something which enables you to achieve solventless extraction. The interest in the enzymatic lysis part of the picture arises because you see it as expressly called out as something you can do. And when we come on to point 4, we will see there is evidence that suggests that the skilled person will perceive it as less problematic in terms of the emulsion. Because although they are interested in bile and achieving the solventless process, the judge found, it's my friend's case, that you would, when you read bile, be worried about the emulsion. So the reason it was done, or the reason it was not done before, is that you don't have this thought process that you have with bile. You don't have, oh, here's a way of avoiding solvents that I'd like to pursue, common ground. Oh, I've got to worry about emulsions, but that's less with enzymatic, which are expressly called out as an option. So that's really what I mean when I submit that the interest arises from the document itself and what it's proposing. Have I at least made it clear to my lord?
Clearer, thank you.
Clear. And just to move on the why not done before point, a point about why not done before, where you're talking about an obviousness case over a particular piece of prior art, is a much less significant question where the prior art is very recent. Or, in fact, in cases where there's no evidence that anybody was aware of the prior art, but here they couldn't have been. So, we give my Lords the reference to Lord Justice Jacob on that, but it is quite important to understand that the reason that you're taking this forward and the reason that you see enzymatic license as the thing to take up is because it's in bile, and because of what bile promises in terms of avoiding solvent extraction. Now that brings me to the fourth and final point, and that is the crunch point in my submission, because the substance of the judge's conclusion is that the skilled team would be interested in bile, sceptical because of the prospect of an emulsion that doesn't break, and after trying the examples, give up. And the point set out in paragraph 314 of the judgment, we see the judge says, despite our best efforts, there was no evidence that on reading bile, the skilled team would understand the emulsion problem was caused by the violence of mechanical lysis, that enzymatic lysis would produce a gentler emulsion, and this thought process would point the skilled team towards taking up enzymatic lysis. So the big picture is this. They'd use homogenization only and fail because they wouldn't perceive when reading bile that the problematic emulsion is stronger with homogenization, or to put it the other way around, as I emphasised earlier, it's the same side, it's two sides of the same coin, weaker or gentler with enzymes. And the obvious point here is if they perceive enzymatic lysis would give a weaker or gentler emulsion, that would push them to it. And of course, it certainly would if homogenization produced a strength of emulsion that wasn't breakable. And we see at the foot of this page, we're looking at paragraph 314 now, but we see at the foot of this page, 316 that I showed you before, where the judge said the issue was reasonably finely balanced, and he refers to with better evidence, which gave reasons why the skilled team would focus on enzymatic lysis without hindsight. The outcome might have been different. Well, my lords, we say the judge overlooked the fact that there was evidence, and as I explained before, this is not a case of a piece of CGK, but of perception of the skilled team when considering bile, having the concern that my friends advance as to the problematic emulsion forming. And I've repeated that point, that it's not a CGK point, because we see that he likes to treat it like that. When we see him dealing with the fourth point, so on page 11 of the skeleton, we see the label that he gives it, not CGK, that enzymatic lysis produces a weaker emulsion. But that's not what, or how the judge characterised the thing he said there was no evidence of. Para 314, he's clear he's after evidence as to what the skilled person reading bile would think or understand, which is different to pre-existing CGK. And we explain the context of this evidence in paragraphs 49 to 52 of our skeleton. I've touched on some of this already, but I want to pause and make sure that my lords really have it. DSM's obviousness case was not that bile would be disregarded. Sometimes in cases you get that, not that. It would be of interest and would be taken forward. But there would be scepticism that an unbreakable emulsion would form, such that the skilled team did nothing more than attempt the examples and give up. But crucially, and this is our paragraph 51, the fear of the unbreakably strong emulsion was said to be a consequence of the violence of homogenization. Or to put it more precisely, the skilled team would perceive this as a particularly acute problem where homogenisation was used because of the high turbulence conditions. And I've already explained that's how the perception was explained in my friend's own evidence. And we've referred to Dr. Wynne here at paragraph 51 of our skeleton. It's what I showed you in his main report, paragraph 159. And I showed you Mr. Dweppen saying something similar. Now, my lords, have my submission that putting evidence in terms of a perception that the emulsion fear was particularly acute when homogenisation was used is no different to identifying the other side of the coin, that it's not so troubling if enzymes are used. And my skeleton at paragraph 51 gives my lords a further important reference on this to Dr. Wynne. Can I show you that? So we now need supplementary bundle 2, tab 18 at page 470 of the bundle. And is actually a similar number, 476 of the manuscript, so the top right-hand corner. And to put you in context, we're debating how bile would be perceived by the skilled reader. You see that at the top of page 476 using the manuscript numbers. And he said he would be concerned with an emulsion, but bile doesn't actually suggest there is an emulsion. I ask him at line 6, but you say reading it, you would be concerned about an emulsion. He replies at line 8, yes, and refers to the need to test it as captured in the document. At line 10, I point out that the particular concern he identified in Bile's examples was the homogenizer. And he says no at line 12. It's because an emulsion would form. And I point out that was because of the homogenizer. That's line 13. And his answer is also that certainly it would make it more, would exacerbate the problem. Would exacerbate the problem. So, my lords, just pausing at that answer, reiterating the thrust of his written paragraph 159, use of the homogenizer makes the problem bigger in this witness's language, exacerbates the problem. We must read on to make sure we have the whole thrust of the evidence. He goes on at line 17 to explain his view that there would be a problem with an emulsion irrespective. Pausing there, what we are looking for is not evidence that there would be no emulsion issue at all without homogenisation, but evidence that the emulsion would not be so strong or gentler if it's not used. At line 22, I ask him to look at paragraph 159. That's the paragraph we've been looking at. And I draw attention to what he said at the end, referring to particularly under high turbulence conditions such as those in a homogenizer. I'm now at the top of manuscript, page 477. He agrees he did say that particularly. At line 7 he says, but not exclusively. At line 8 I say, sure, the homogenizer is likely to cause a problem or exacerbate it. And your skilled person would tell Mr. Dweppen or his equivalent, surely. Line 11 he says his original reading was questioning whether it would work at all. It begins to suggest he did not think about the method of, and then he stops and he continues instead, yes, whether it would work or not. And at 17 I say to him, sure, the reason you give is the fear of an emulsion, which you say is a particular problem using the high turbulence condition of a homogenizer. And the answer, line 20, is which emulsion is the fear that will particularly happen if you did it, please note this, as described in the examples, which is obviously homogenizers. And in fact, with nothing to aid the centrifugation as well. So it's a fear as to something that will particularly happen with homogenizers. And my lord should read on, because this passage goes straight into the passage we quote in the next paragraph of our skeleton. I turn from one side of the coin, the exacerbation of the problem by homogenizer, to the enzyme side of the same coin. At line 22, I suggest an enzyme would be better on that score, and he agrees. If you could get it to work, it would potentially be better than that, yes. So, my lords, just pausing here, looking again at what the judge said in his paragraph 314 of the judgment, what the judge said was that there was no evidence to support the suggestion that the skilled team reading bile would understand the emotion problem was caused by violence of mechanical lysis, that enzymatic lysis would produce a gentle emulsion, and this thought would point the skilled team towards taking up enzymatic lysis. And as I've said, he reiterated in para 316 that the point was finely balanced and that what was missing was evidence that identified a reason why the skilled team would focus on enzymatic lysis without hindsight. Now, in my submission, if you ask yourself the question, can those paragraphs stand, particularly 314? Well, my submission is that what I've been showing you, both the written evidence and the cross-examination material, is actually that which the judge said was absent.
It's quite a short bit of cross-examination, that, when you say it would be better. And he says it would potentially be better. It doesn't...
The very last question. That's why, my
But it doesn't go into how much better, is it a lot better, is it better in a way that would, in a technical sense, mean that you might think, well, it would work then, whereas it wouldn't work if you'd bashed up the cells. To use your language, that one thing might well work, the other one wouldn't. Anything like that it's a very truncated bit of cross-examination.
Well, let me meet that head on. There are two answers to that point. One is, we're concerned with the judge thinking there was no evidence. He said there was no evidence. There's a different thing by saying, I've looked at this and I'm assessing it in this way, and actually he just overlooked this evidence. He's clearly not gone through the analysis that your lordship has just then put forward. But the second, perhaps even more significant one, is this. That's why I showed you the written evidence and the run-up to it in terms of the exacerbation of the problem. Because and that's why I've made the submission to my lord that these are two sides of the same coin. And that was deliberate, because all of this is evidence going to the point in my submission. The two pieces of written evidence I showed you saying that it's likely to be worse with homogenisation, the problem is going to be worse or exacerbated. I think exacerbated came in the cross-examination, but earlier on in the section. And that's why I've shown my lords all of it. Because I don't just say, look at that one question and answer, the judge is wrong because look at that. I say, we've got all of it. And it is no different to say homogenisation is somewhere where you'd think the problem was more acute, worse, however you want to frame it. No different saying that and saying that it's going to be a lesser problem with enzymatic lysis. So that's the answer. And to say that there's no evidence on that is simply wrong in my submission, and the judge plainly overlooked it. And the reason the judge said that was missing, reason that you'd look at enzymatic lysis without hindsight, is because you would perceive the emulsion issue to be particularly acute or exacerbated with homogenisation, and you're worried about it. So you go somewhere, i.e. enzymatic, where you don't have that exacerbation. And I emphasise again, it's not because of a pre-existing piece of CGK, but because when reading bile, that is the thought that would occur to the reader when you think about the emulsion problem that you perceive is coming your way.
Is that something you get out of bile itself, that distinction between CGK and that thought process? Or no. Is it just a person with CGK who knows that?
Yeah, the point
doing that, putting those two things together, and if so, is it really anything more than CGK?
No, you do get it out. You get it from reading bile because it comes. You're forced to think about it because you worry about the emulsion problem. The whole nature is quite interesting. It's one of their documents, but their case is that you would read it, and particularly you'd read the examples, and you wouldn't really believe it. And so the thought process and how it occurs to the reader as they read it is they read it and they are worried about the emulsion. And they're particularly worried about an emulsion in the examples where you're only using centrifugation without salt or raising pH, and you're using homogenization. And I've shown you that they say that the homogenization would make you particularly think that it would be a problem. And so all of that pushes you to think about this because of bile. So it is different.
But how does that an answer to my Lord's question? Because it's one thing to say that bile puts the question in the reader's mind. It's another thing to say that it puts the answer in the reader's mind if the answer is not already common general knowledge.
Well, it's an answer to my Lord's question because certainly I understood the question was directed to how does the skilled reader start thinking about this? Do they already know it? And it's an answer to my Lord's question in that something that a reader can perceive when they're confronted with a particular disclosure does not mean that it's already something that they have thought about or done a test, or somebody else has done a test, such that it's in the CGK, that it's pre-existing.
No, I can understand. As a matter of principle, it doesn't have to be common general knowledge. And it doesn't have to be expressly spelt out by the prior art. You can imagine that there are things where reading the prior art, even though it's not expressly spelt out, you find the answer to the question. But I'm not quite sure how you say that this is such a case, because what is it in bile that tells you, even though it doesn't say in words of one syllable, if you do it with an enzymatic lysis, you will have a weaker emulsion, and therefore that will be less of a problem. Where does the skilled person get that out of the document if they don't already know that?
It's not, let me deal with the if they don't already know that. There are things that won't be part of the CGK because you've just never been caused to think about it. Nobody's ever done a test. It's not a pre-existing thing that's in your head or on a book on the shelf. But there are things that you can perceive when you read a technical disclosure because of what you're forced to think about. So my answer to my Lord is that they don't have it in their head because they've never been forced to think about, is there a difference in the strength of the emulsion? But when they do read bile, and they're faced with these examples which they are really worried won't work because of the emulsion, it's common ground that their evidence was that one of the reasons you'd worry about it, particularly so, is because they used a homogenizer. And that's because of the high shear force. So you don't come to it knowing it already, but what you perceive when you perceive the problem. And there's nothing in bile that tells you it won't work. But you perceive the problem in the examples, and you're focused on the worry about an emulsion. And as we've seen, their experts said it would be a particular worry because the examples are using a homogenizer. So that thought process is necessarily focusing the reader on the fact that you've got this high turbulence that's going on so that the emulsion is going to be a particularly strong kind. And as I've said to you, that is a comparative thought. If it's particularly strong with homogenizer, that's because it's not as strong without other means.
Okay, last question on this point. When the judge says no evidence, I mean, any judgment is capable of having been better expressed. But it might be said that the point that the judge is making is there's no evidence that it was common general knowledge that enzymatic lysis would give you a weaker emulsion. Because of course, and you accept that, because let's think about it, if there was evidence that it was common general knowledge that enzymatic lysis would give you a weaker emulsion, then you can put two and two together and make four.
Of course. We wouldn't be having this debate.
Yeah.
Sure. My answer,
So might that not be what the judge meant?
no, my lord. Look at the words. It says on reading bile. And this is an analysis that happens because of what you read in bile. And the judge is absolutely clear about what he's looking for, that he says doesn't exist. What the skilled team on reading bile would understand. He actually says it. It's the second line of 314.
Yes, but that depends on the validity of the distinction that you're drawing.
Well, if you say there's no real distinction, then that's a different point. But it's quite clear that the judge is definitely focused on what would occur to the skilled person reading bile. And let me tell you why he's concerned about that. Because the essence of what he's relied upon in these 4 points, and this fourth one in particular is really the key point, is he's worried that looking to enzymatic lysis is hindsight. That's what he says in the overall conclusion between 314 and 316. I think 315 says that. Right. And hindsight obviously means I'm not allowed to know what the claim is or what the patent is, but I'm allowed to be reading bile. This isn't based upon CGK only. Obviously the person has their CGK, but the judge is worried that bile, albeit it actually recognises and identifies this as an option, the judge is rightly concerned to make sure that he's not using hindsight. And he's concerned with what would occur to the skilled reader when reading bile, and he says so. And that is the right thing to be concerned about. And he simply overlooked the evidence. And my lords know that he gave permission himself on this. Now, what is my friend's answer to this? There's 3 relatively brief paragraphs on page 11 of their skeleton. Paragraph 43 simply states the point, seeking to argue the point appeared for the first time in our closings. That's not right. If you've seen themselves, they had it in their written evidence, put the other way round as to what would be stronger, and it was developed in cross-examination. But that paragraph, apart from making that submission, does no more than state the thing. 44 suggests the finding was well open to the judge, and in fact they go on to suggest no other conclusion was open. In my submission, that's a rather bold contention, given what the judge is saying, that there was no evidence on the point. This is not, as I emphasise, the judge looking at the evidence, analysing it, and concluding that a decision will be made one way or the other. He simply says that there was a hole in the evidence. And in any event, one can see from the rest of this paragraph, they're in fact seeking to, again, to hit the wrong target. There's a reference back to their earlier paragraph 12, and that's directed to what was CGK, so what the skilled team thought or knew before reading bile. And the answer is the same to the second point that my friend makes in paragraph 44, a complaint, we should have included it in the document of CGK, either that which was agreed or the list to that which was in dispute. something one might have expected the judge to say too if it was a CGK point. Now, my friend's last paragraph suggests that the judge didn't overlook the evidence. Now, what we see here in this paragraph is my friend properly accepting we relied upon it. But we also see that this paragraph is still directed to the CGK point. My friend seeks to rely upon submissions he made orally as to what there was, as to why there was no point of CGK, that I didn't attempt to argue it was CGK. And even if the argument had been directed to the right point, so it wasn't the CGK Aunt Sally, the submission couldn't support the paragraph in the judgment in my submission because that paragraph says there was no evidence on the point. As I've said, it doesn't explain why the judge preferred one way or another. So it's pretty extraordinary in my submission that my friend seeks to support a paragraph that says there's no evidence on the point by emphasising that it did exist and he made submissions on it. In any event, as I was just emphasising to my lord, it's not just the oral evidence, and it's certainly not just that one question. It's the written evidence and the whole run up to that over the 2 pages of manuscript. My lords, a final point. It really is a rather strange suggestion for my friend to be saying that it isn't a matter for Dr. Wynne either, given that he led evidence on precisely that. Is his paragraph 159. As I've said, it is precisely that, because you don't change the substance by putting the relative point the other way round. And that really is the sum total of what my friends have to say in support of the judge on that. And in my submission, that won't do. They go on in their section headed overall point to suggest our case is based upon hindsight. And look, we've been through each of the 4 reasons the judge gave for his overall view. It isn't hindsight in my submission. And what the judge said was reasonably finely balanced, was determined the way it was because the judge wrongly overlooked the kind of evidence he said would have been key, which he thought didn't exist but did. Now, my lords, of course, I don't win automatically by showing, my lords, that the judge erred and overlooked relevant evidence. What I get to is by showing that he overlooked the evidence saying there was none, is that I've identified that he erred in a way this court will recognise as an error of principle, one upon which this court will act. But that just gets me to my lords having the evaluative exercise to carry out afresh. And there's a danger in these kinds of appeals to think that if you get home on that point, you must be home and dried. And I accept that I'm not. But on that, I have to persuade my lords, exercising the evaluation afresh, that it was obvious. And on that, when seeking to take bile forward, we say it was obvious to use enzymatic lysis. And we give my lords the key points we rely upon in paragraph 55 of our skeleton in describing the thrust of my friend's case. And the point here is that it's not my friend's case that bile would be read and put to one side. On the contrary, the skilled team would be interested. They would seek to take it forward. But on my friend's case, they would fear an emulsion, specifically one that was so strong it could not be broken. We also include in paragraph 55(1), that fear was particularly acute when lysis is done by homogenisation, because it was in the written evidence of their experts, as I've explained. And according to my friend's case, the skilled team would expect bile examples wouldn't work. They used homogenisation, and of course they only used centrifugation without any of the other methods that would assist. On subparagraph 3, my friend takes issue with that in his skeleton in paragraph 48, characterising it as a finding we wish the judge did make. This is the very point we've been on, where the judge overlooked the evidence. The point is that the skilled team would appreciate enzymatic lysis would be better in the sense that it's gentler. It didn't exacerbate the problem like homogenisation would. It's precisely the effect of the evidence we've looked at, which the judge overlooked. And the last point we make is the absurdity of the position that the skilled person would seek to do the thing they would expect not to work, or expect most not to work, and not do the thing that would be expected to be more likely to work. And we know on the judge's findings would work. We submit that it makes no sense in the light of what we've been through, and in particular in the light of the fact that Bile particularly calls out enzymatic lysis as one of the options. They wouldn't just stop at the examples, the thing that they think is the most likely thing not to work. They would be driven to enzymatic lysis either by the suspicion or actual demonstration about their fears of an emulsion being heightened with homogenisation. As I think I've said already, this was not any kind of outlandish technique. It was CGK and expressly called out as an option. And we make a few further points. First, the judge rejected DSM's mindset argument against any lysing technique that wasn't mechanical. So that's the homogenisation or bead milling. That's paragraph 264, which we draw attention to in paragraph 58 of our skeleton. We also make an important submission at paragraph 57, which I've already foreshadowed, but it is not necessary for me to show obviousness that enzymatic lysis is the most obvious thing to do. It just has to be one of the obvious things to do. And we say, in a case where the document identifies a plurality of alternatives, they may each be obvious. Specifically, when you take account that chemical is not being preferred, all we've got is enzymes and physical lysis as the alternatives called out to homogenisation. And this ties in with a point we make in paragraph 59 and 60 of our skeleton. We draw attention to the evidence of Mr. Weapon set out in paragraph 294 of the judgment. That's bundle page 205 in tab 12. And we can see the point actually being made from the foot of the page 205 over to the top of 206. Made by me. The enzymes was one of the technically obvious things reading Bile. So if you read over to the top of page 206, his answer was directed to suggested issues with identifying the enzyme, a point that didn't find favour with the judge. And also the judge treated this answer as an answer that they could do it, contrasting with whether they would. As he said, it's a possibility that they would have looked at that. So except it's a possibility, the judge says it's a could-would dichotomy. And let me just make my submission on that. Of course, that could-would is sometimes a helpful distinction, particularly where there may be a large number of possible avenues. In such cases, just identifying one thing as something that could be done rather begs the question. And one sometimes sees it in patent cases, as my Lord Justice Arnold will be well aware. But to be clear, we're not trying to say this judge got the sense of this answer wrong, as my friend seeks to suggest, in that he was trying to suggest he was accepting that they definitely would. The point we're making is simply that the could-would analysis he adopted is misplaced in the context of a document that only has a very small number of alternatives to look to. In fact, two alternatives, as I've said, if you discount the chemical. And I make that point good by emphasising something that I've said already, that there can be more than one obvious thing. So you can have an answer that the skilled team could look to enzymes, not that they must. But you can't say, well, it's got to be a would answer rather than could. Because if in that context, you would be setting up a structure where only one thing could be obvious. The thing that they would do. So you've got to be quite careful. As always in these cases, context is crucial. Could, would is a helpful thing when you've got a high number. Where you've got one or two, and it's accepted that one of the things that the skilled team could do is one of the 2 or 3 things identified. That is a really strong pointer to obviousness. So, my lords, the upshot is we say the judge should have found that one of the obvious things for the skilled team to do when seeking to take bar forward was to look to enzymatic lysis that was expressly called out. And the reason to do so without hindsight, the thing the judge thought was missing was in evidence, and that is something that would occur to the skilled team when reading bile. It's the perception of the fear of an emulsion, the particularly acute perception that they would think they couldn't overcome or would be exacerbated when homogenization was used, so it would push them to enzymatic lysis. And although I've come to the end of my note, is there anything else that I can help any of my lords on?
No, thank you very much. Yes, Mr. Abrams.
Just have a moment to sort myself out. My lords, I'm going to start with addressing some points of CGK which are relevant to both patents, although the priority dates are different for the 2 patents. I believe that everything I say about the CGK applies to both patents and their priority dates. And then I'll move on to the 2 patent appeals. So there are 3.5 points of CGK that I need to touch on, and I can do that by reference to the judgment on CGK. So that's Core Bundle, tab 12, page 155. So the first point is just to identify the upstream-downstream distinction referred to at 30. So the goal of the upstream process is to create a large biomass rich in lipids, i.e. lots and lots of cells, each cell full of oil. Then the downstream process is the extraction of the oil from the cells and then the subsequent refining. So 155 and 801, they're both downstream patents because they focus on lysis and the subsequent separation and isolation of the crude oil, respectively. The second point is on organic solvents. You'll have picked up that in this case, when we say solvent, we mean organic solvent. So at the priority date of both patents, all known processes for extracting algal oil involved organic solvents. And the 2 CGK processes are illustrated on page 176 in this very helpful figure 13. So the first is the hexane extraction technique shown here in blue, which the judge described in the earlier paragraphs. That involves drying the cells before adding hexane and then lysing them mechanically. And the judge described this from paragraph 121 onwards, where he explained the downsides of using hexane, and they are very serious downsides. Then the alternative method was the free-elex process, shown in red here. The judge described this in 128. So here, the cells are lysed while wet, and then isopropanol or other polar solvent is used to separate. And paragraph 131 on this page records that it had long been appreciated that in an ideal situation, the extraction process would be entirely aqueous. By aqueous, we mean water-based, not using an organic solvent. The problem is the emulsion that forms between the oil and water. And it's as a result of that, either you have to dry the cells first and lyse them in the absence of water so that no emulsion forms. That's the hexane process. Or you get an emulsion and you use a polar organic solvent to break that emulsion. That's the free Elex process. Now, if we fast forward to paragraph 656 of the judgment, on page 267, these are various treatments that were CGK, sorry, page 656. These are various treatments that were CGK for attempting to break an emulsion. And you see number one is use a polar organic solvent. As the judge averted to at subparagraph 5, some emulsions are easier to break than others. And my learned friend showed you Dupin 2, paragraph 36, which expanded on that. So, for example, a vinaigrette is an emulsion, and it can be broken simply by gravity. You leave it for 30 minutes, and the oil will separate from the vinegar. And that won't work for mayonnaise, which is a stronger emulsion. And it certainly won't work for an emulsion formed during microbial oil extraction. The point to stress is that even though there were various CGK methods for breaking different emulsions, which the judge has set out here at 656, nothing had been found which worked on breaking a microbial oil emulsion that did not involve an organic solvent. And the other point to stress is that these had all been tried on microbial oil emulsions, including combinations, which is the judge refers to at little 6. The judge didn't say expressly that they'd all been
Sorry, I'm a bit puzzled. You say nothing found did not involve an organic solvent, which would imply these are not alternatives but cumulative. Whereas I read this as a series of alternatives. Am I wrong in reading it that way?
They're alternatives and so little Roman 6 is combinations. So the point is that...
Well, exactly. So that suggests that 1 to 5 are alternatives. So
Indeed. And my point is that they'd all been tried, including combinations have been tried. I may have misunderstood my Lord's question. I apologise.
I may have misunderstood what you said originally.
Okay.
But you accept that we have here 5 alternatives and then combinations.
Yes, absolutely.
Right.
And the points are that they had all been tried in trying to break a microbial oil emulsion for the purpose of developing an aqueous process. And nothing had been found to work on a microbial oil emulsion that did not involve polar organic solvent. Perhaps the key to this paragraph is the word seeking at the beginning of 656. So just for your note, it was common ground on the evidence that there'd been extensive attempts to find an aqueous process involving trialling out all of these methods and combinations. And we've given the evidence references in our 801 skeleton argument at paragraph 17. And this will be relevant at a number of points, in particular to the issue of expectation of success, i.e. the skill team knew that these methods at 656, including the combinations, had been tried, and other than methods involving polar organic solvents, they had failed in the context of microbial oil emulsions. The third topic on the CGK concerns lysis, and my learned friend showed you paragraph 124 referring to the 2 mechanical means which were CGK. So in the context of microbial oils, lysis was done by mechanical means, those 2 mechanical means. Equally, there was no dispute at trial that the skill team would have known that enzymes can be used to lyse cells. For the skilled person, they would have done that at O level. But the judge was very alive to the point that just because something was CGK doesn't mean that it was CGK to use it for any particular purpose. And he specifically drew that distinction at paragraph 166, which you have seen this morning. Now, importantly, The judge didn't. Okay, step back. My learned friend showed you a passage where the judge said that using lysis in the lab was something that the skilled person would be aware of. And of course it would. Indeed, they may well have done it in the lab during their O-levels or A-levels. But the judge did not find that it was CGK to use enzymatic lysis in the context of extraction of microbial oils. That was a deliberate non-finding, and it was based on the evidence. And we've given you the evidence references this time in our 155 skeleton argument, footnote 2, and I'm just going to show you the first of those. It's in the first supplemental bundle, tab 7, page 209. Paragraph 137, please could you read? And, my lords, it's clear that the judge accepted this. It's clear from paragraph 166, which we looked at. Another place that it's clear from is paragraph 274 of the judgment. And I say that because it's sub 3, when he's discussing B, he says that enzymatic lysis was known at a general level. Sorry, 202 of the bundle, 274 sub 3. And in the middle of that paragraph, he refers to enzymatic lysis being known at a general level. And just to further illustrate the point, the point is well illustrated in the single cell oils book, which the judge refers to in the part of the judgment we're going to be looking at. So this was a book which was post-priority but accepted to reflect the common general knowledge. It's in the second supplemental bundle, tab 13, page 383. So on page 383, we have the heading pre-treatment and cell disruption. It says that microorganisms considered in this section have extremely tough cell walls. Then in order to release their cellular content, a number of methods for cell disintegration have been developed. Chemical, biological, and physical. Biological obviously means enzymes. So that's your O-level science, that these three methods can be used to break cells. Then some of these methods have severe limitations with regard to large-scale application compatibility with product or cost. Then we have a single sentence on chemical methods. It's important to knowledge of cell structure and composition is therefore important. And then the next sentence is about mechanical methods, and then the whole of the rest of this section on cell disruption focuses on physical, i.e. mechanical methods. It says that they've demonstrated good performance, that's 3 lines up from the bottom. And then there are various considerations. For example, over the page, about 10 lines down, for schizoketrium, it's got a weaker cell wall and energy requirements for disruption are significantly lower. And so that complete focus on mechanical methods, while acknowledging that in theory there are a number of ways of breaking a cell wall, reflects this common general knowledge as Mr. Dupin described it in his evidence. And the point goes a little bit further than this. The CGK did not include any knowledge as to which microbes could be usefully lysed by enzymes, which enzymes were useful, what conditions were appropriate for enzymatic lysis for the purpose of single-cell oils, or what a complete process, including enzymatic lysis, would look like. Again, we've given evidence references to that in our 155 skeleton argument at footnote 4, and your lordship will see how this feeds into the judgment, the judge's judgment on Beale. I said 3.5 points because I was going to address what we understood was a suggestion that it was common general knowledge that enzymatic lysis would lead to a weaker emulsion. That's not put forward as a point of CGK. But it is important that that's now recognised as not being something that a skilled person would know. So, my lords, I'm now turning to the appeal on 155. And my learned friend took you to the 155 patent, and he took you to Beale. I can just pick up some key points on the Beale prior art, again by reference to the judge's judgment. So if you have the core bundle, tab 12, page 186.
Sorry, which page?
186 of the core bundle. So this is where the judge deals with Beale, although my first point on Beale doesn't actually come from this section. My first point on Beale is that the key message of Beale is the suggestion of doing solventless separation using centrifuging with some other optional extracts, but crucially without an organic solvent. It's the without an organic solvent that is the key message of Beale. That's what it says in the first line of the abstract, which you were shown, without a solvent. And the judge found as a fact that that is what the skilled team was seen as being new in Beale. And that finding of fact is at 312 of the judgment. Second, my learned friend showed you the teaching on all the different microbes that Beale mentions, and the judge referred to this at 187. Schizochaetrium is not identified. The order in which Schizochaetrium lives is mentioned, but it's wrongly placed as a fungus, which the judge noted at 187. Third, Beale has this section on lysis. Again, my learned friend showed you this, and the judge refers to it at 190. And the section lists the same 3 lysis techniques which appear in the single-cell oils book. And the disclosure just simply says enzymatic lysis, and little more than that. It says, it mentions some enzymes. But Beale's disclosure adds nothing to the skilled team's knowledge of enzymatic lysis from the CGK. The judge noted that expressly at 191 and 311 to 313. And of course, Beale says that homogenization, a mechanical method, is the preferred method of lysis. It would have been very strange if it said anything else. And that method is used in both of Beale's examples, as noted by the judge at 206. Fourth point I want to make, and this is something my learned friend skated over, is that Beale addresses the question of separating the oil from the aqueous phase at paragraph 28F. That's set out by the judge at 201. So, centrifugation is the primary method, and then it says optionally you can do some other things. One is adding salt, which obviously was a CGK method of seeking to treat an emulsion, and it mentions some other things. The experts agreed that some of these others would not be regarded as plausible by the skilled team. So, for example, at 884, when the judge was discussing the Hendrick prior art, which is materially the same as this, he noted that the pH, the skilled person would not regard this suggestion of a pH shift towards alkaline as being plausible. And obviously the suggestion of using emulsifiers to separate is ridiculous. that paragraph deals with separating the oil from the debris. So now I turn to the judge's conclusions on Beale, and they start at page 202 of the core bundle, under the heading My Conclusions on Beale. My learned friend basically skipped straight to 310 and 311, but these paragraphs from 274 are absolutely critical to understanding the judge's reasonings. So he started at 274 and 275 with a finding that the skilled team would regard Beale as a strange document for a number of reasons which he set out. So first of all, Beale seemed to be suggesting that it was putting forward lysis as a thing to do, whereas that was already a thing that was done. And so it was, the suggestion was, his words, significantly out of step with what the skilled team would know was happening in the industry when mechanical lysis was used. Second point, perhaps the biggest problem, is that the skilled team would not believe its central claim. Very importantly, Beale does not even recognise that an emulsion would form when utilized without drying the cells first. That's also in point 2. And as a result, the skilled team would treat its claims with scepticism, if not disbelief, and be cautious about it, as he said in 275. The third point in 274 is that they would regard it as speculative, with some of the claims being speculative, and it would be, the skilled team would be sceptical about it. So we call this, we call 274 and 275 the judge's first conclusion, under the heading My Conclusions on Beale. The judge didn't say that the first conclusion would lead the skilled team to throw Beale away. At 276 and 277, the judge found that the skilled team would nevertheless try out Beale's examples, which use mechanical lysis, of course, and that these wouldn't work, by which I mean the results would be such that the central teaching of Beale, that centrifuging without solvents, would not be seen as worth taking forward. So we call that the judge's second conclusion. Then at 279 to 283, the judge considered the contention, which they did advance below as a point of CGK, regarding enzymatic lysis and a weaker emulsion, and rejected this. Then at 284 to 308, the judge set out and analysed Mara's case on obviousness, and you can see how many different steps it required and what they involved. And we just note that steps 3A, B, and C involve researching enzymatic lysis. And that's because the skilled team can't just do enzymatic lysis. Pursuing that suggestion, if they decided to pursue it, would involve a research project to work out which organisms could be lysed by which enzymes and what the conditions would be. Note also that at step 5, I'm looking at 285 sub 6, it's been added by the judge because as he recorded at 286 and 308, Mara was quite unclear what their case was about separation. That's because their case went straight to enzymatic lysis. Their case was the skilled person simply picked up the document and went to enzymatic lysis, and not the case which my learned friend is now pivoted to, which is that the skilled person is trying to work out how to solve the problems with Beale. I'll come back to that point. Then at 309 to 3010, we have what we call the judge's third conclusion. This was that the skilled team would not investigate enzymatic lysis in the light of Beale, and he gave out his reasons at 311 to 315. Before we break for lunch, can I just stress why we say it's important that all these components of the judge's overall conclusion are recognised? The point is that the skilled team reads Beale. They have serious doubts about it. It's a very strange document, and its central claim is not credible. Nevertheless, they try out Beale's examples, and their doubts will be shown to be well-founded when the examples failed. At that stage, the skilled team would conclude that they'd wasted enough time on the document. Its teaching was not worth taking forward. Those were the facts found by the judge, and none of them are appealed. And the question is whether the judge was entitled to find that having got to that stage, having wasted all that time on the document, the skilled team would not then head off into researching enzymatic lysis. And that is the question that the judge had to ask and answer, and that's the question which my learned friend has to attack. So, my lord, that's probably a convenient time.
Perfect. Yes. Thank you very much. So we'll start again at 2 o'clock.
Court rise available.